works in Florida. So getting right into it here, to be eligible to serve on your board, there's a couple of different ways. If you're a new community that's either developer controlled or recently turned over from a developer, then you know that the developer appoints the initial board, which consists of their own representatives. And then once it's time to transition the board to membership, to owner membership control, the members will elect the first board of directors after turnover. Now, generally, when a vacancy occurs on your board of directors, the remaining directors will have the right to fill that vacancy, as opposed to having to conduct another election by the membership. So unless the remaining members opt to conduct a special election, you're going to see those remaining directors fill the vacancy, and that's the more common practice. Depending on the term of service in your documents, for example, 1-year term or a 2-year term or even a 3-year term, the vacancy will either be filled for the balance of the term of office or until the next annual meeting, depending on how your documents are drafted. The default is for the balance of the term of the seat that's being filled, okay? To be eligible to serve on a board, you have to be at least 18 years of age. You cannot be more than 90 days delinquent in the payment of any fee, fine, or monetary obligation. If you're an HOA, and if you're a condominium, you cannot be delinquent in any assessment, not monetary obligation, but any assessment as the last date that you're eligible to run for the board, which we'll talk about in a few seconds here. If you've been convicted of a felony and your civil rights have been restored for a minimum of 5 years prior to you running for the board, then you are eligible. When we talk about civil rights, we're talking about things like your right to vote, your right to serve on a jury. There's a question about whether or not your right to bear arms has to be restored in order to be eligible. The Department of Business and Professional Regulation has flip-flopped its position on that. Initially, it took the position you had to have your right to bear arms restored, and then it issued a declaratory statement about 5 years later saying, nope, you don't need that. You don't need to have your right to bear arms restored to otherwise be eligible, as long as all your other civil rights have been restored. If you've been suspended or removed from a board of directors by the department, then you are not eligible to serve on a condominium board. Anybody that's been charged with felony theft or embezzlement involving association funds will not be eligible pending the resolution of those charges. You'll be temporarily removed from the board, and that vacancy or vacancies would have to be filled until such time as the individual is cleared of those charges. Now, there are certain special requirements for directors of condominium associations. Co-owners are not allowed to serve on the board of directors unless, one, they own more than one unit, or there aren't enough eligible candidates to fill all the vacant seats on the board at that time. So if you've got an open seat on the board, nobody's willing to step up, then a co-owner would be able to serve. Not the most ideal situation, but it is permissible under the statute. Now, for condominium associations, we do have term limits. Those term limits, I think, went into effect, I want to say in, 2018, I think is when the statute was clarified. So this really doesn't come into play until, I want to say, 2026. But if a board member serves 8 consecutive years, they're still eligible to run, but they have to get a higher threshold of votes than the rest of the candidates to order to continue to serve on the board, okay? Or if there's not enough candidates running to fill all the seats on the board. So you would need a 2/3 vote of the owners participating in the election in order to continue to serve if you reach that 8-year threshold, or you can't have enough directors running, and in which case you would still be able to serve. So unless your bylaws or articles of incorporation provide otherwise, the default is that the term of service by a board member is going to be 1 year, and that your term is going to expire at the next annual meeting. So in terms of when your annual meeting should take place, that should be specified in your bylaws or your articles of incorporation. Typically, it's going to say the month that the annual meeting should be conducted. I even see documents where it specifies the exact day and time that the meeting should be conducted. It's important that, especially if you're a condominium, that you hold your annual meeting when your documents require you to do so, because it's considered a statutory violation subject to fine by the department if you do not timely hold your annual meeting. Now, if your bylaws or articles permit service of more than 2 years, then board members may serve more than a 1-year term. In fact, now they can serve even a 3-year term, the way the statute is worded. So if you have a multi-year term of service on your board, we strongly recommend that you set it up where the terms are staggered, so that you're not electing, you're not in a situation where there's years where you're not electing directors, and also you're not in a situation where all your members of your board are up for election at the same time. It's very important, in my opinion, that you have staggered terms so that there are people on the board every year that have some knowledge and history of the affairs of the association, and there's continuity of governance. It's a lot easier on your management company if you have professional management. And if you don't have professional management and you're self-managed, you can only imagine what it's like when an entire new board comes in and they're all new and they're trying to figure out what's going on and how to pick up the ball, so to speak. So strongly recommend staggered terms. And that just requires an amendment to your bylaws. In condominium land, if there is no specified size of your board in your documents, or if it gives a range, the default is going to be that you need to have 5 directors serving. To avoid a worst case scenario, which is receivership, meaning you don't have enough members on your board to run your association, you have to have a minimum of 3 directors serving to avoid that scenario. And that's not a good scenario, because if you end up in a situation where nobody wants to run for your board, and you end up in a court receivership, all the court is going to do is hire somebody like me, an attorney, to operate your condominium, which is going to be very expensive. And all that person is going to do is call for a special election to fill the seats on the board. So it's better to make sure you don't fall below the necessary threshold to avoid that situation. Okay, so now we're going to get into the actual election procedures for associations. We're going to start with homeowners associations. Now, homeowners association elections are very different potentially than condominium elections. The condominium statute has a very specific procedure, which we're going to talk about in a minute, on how to elect directors, whereas the homeowners association statute, Chapter 720 and Section 72306 in particular, defers to the governing documents of the homeowners association. So every homeowners association's election procedure can be different, or have certain nuances to it that are different from another homeowners association. I like to call this the Wild Wild West. Okay, it's anybody's guess as to how any particular HOA runs their elections. I have communities that we represent where they're running their elections like a condominium, and that's not what their governing documents call for. And so the problem with that, and why it's so important to follow the right procedure, is you can end up in a situation where a losing candidate or a homeowner brings an election challenge because you did not follow the appropriate procedure, and that can become very costly to the community, as well as create a lot of disruption and dissension. So it's important that you consult legal counsel to verify you're following your documents election process. And if you don't like the election process in your documents, then I strongly recommend that your board amend that process to conform to the way you want to run the election. Typically, we recommend that HOAs adopt the condominium style of election process, which you're going to see in a few minutes is a very structured process. Okay, but for HOAs, the election process can either be by general or limited proxy, depending on your governing documents. So the difference between a general proxy and a limited proxy is a general proxy is going to give the holder of that proxy the authority to vote however he or she deems they wish. So if you're unable to attend a meeting, you're basically delegating your vote for whoever's running for the board to the person who holds that proxy, and that person is going to be entitled to one additional ballot for every general proxy that that person is holding. So if you've got somebody going around your community canvassing the neighborhood for general proxies, and they show up at the meeting with 50 general proxies, they're going to be entitled to 50 ballots plus one for their own property, and they may be able to dictate the outcome of the election, simply because they did a lot of footwork. Some documents will cap the number of proxies any one member can hold, but those types of provisions tend to be rare. A limited proxy, on the other hand, is a little different. In that case, if the election process permits, what you're doing there is you're specifying your vote for the candidates that are running, and the proxy holder is simply delivering your vote to the membership meeting, and they do not have the discretion to vote on your behalf. So that's a very different situation. Now, a secret absentee ballot is more akin to the way condominiums associations vote for directors, and that has to be specifically authorized in your governing documents, presumably would be in the bylaws, and that is that you can vote by ballot absentee. And the only way that that's going to work is if you have a process in place where people are able to nominate themselves for the board in advance of the meeting, and then there would not be any nominations taken from the floor of the meeting. If you're going to have nominations at the floor of the meeting, it's difficult, if not impossible, to have an absentee ballot, because you're going to disenfranchise anybody who's running or who's declaring at the meeting itself. So if we're operating under a secret absentee ballot process, we're probably running a condominium style election for our homeowners association. And then, of course, I do see some documents that say the only way you can vote is in person, by personally casting the ballot, which means you got to show up and you got to vote. Otherwise, you're not going to have your opportunity to vote. Okay. Unless there is a advanced nomination process specified in the governing documents, then a member has a right to nominate himself or herself at the annual meeting. Alternatively, if the person provides a letter of intent to accept the nomination, somebody could nominate a member, another member can nominate a member, as long as they've indicated in writing they'll accept the nomination. Now, for homeowners associations, there's a specific quorum for the election. You have to have 30% of your membership present in person or by proxy to hold an election. If you don't have a quorum, then the old board is going to roll over. Again, unless you have some type of process where there's advanced nominations and you have less candidates running than seats open, or the exact same number of candidates running as there are seats open. If that scenario exists, then we don't have to hold an election, and it doesn't matter if we have a quorum or. So again, we're only going to need a quorum for an HOA if we have a contested election scenario. And you'll see in a minute that for condos, there's a lower threshold to conduct an election. Again, as I said, an election is not required unless we have more candidates than vacancies. Secret ballot voting, if your governing documents can, permit secret ballot voting by people who are not in attendance, then there's a very specific process by which those ballots have to be returned to the association at the annual meeting to be counted. You're going to have two envelopes. One is an inner envelope that's going to be unmarked. It's just going to be marked ballot envelope, and your secret ballot's going to go inside that envelope. And that secret ballot envelope is going to go inside a larger envelope. We call that the outer envelope. And that outer envelope is going to contain your identification information, your name, your property address in the community that we're conducting the election, and a line for your signature. Okay. If the outer envelope is not signed, your ballot is not going to be counted, and it's going to be disqualified. Also, if there's more than one ballot inside the ballot envelope, your ballot's going to be disqualified. Now, that pretty much covers the different possibilities for an HOA election. So now let's talk about the condo procedure under 720. So under 720, it says that we have to provide multiple notices of the annual meeting. We have to provide two notices. The first notice is going to go out at least 60 days prior to the date of the annual meeting, okay? And so when we're calculating, I see this mistake happen quite a bit, we got to calculate backwards. So you're going to first establish when is our annual meeting date, and then work backwards for that minimum 60-day notice, not count forwards, otherwise you're going to miss it by a day. And that first notice is going to inform the membership of the date, time, and place of the annual meeting. And it's going to inform candidate members that if they wish to be a candidate, they have to submit a written notice of intent to be a candidate for the board, not less than 40 days prior to the annual meeting. Okay. If you do not submit that written notice of intent by that deadline, then you're not going to be on the ballot to run for the board. If you're an existing board member and you make the decision not to submit your notice because you think there's not going to be enough candidates running, you're playing Russian roulette about whether or not you're going to end up on the board. So if you are looking to run, you need to get that notice of intent in timely, okay? And then the association has to provide a written acknowledgement or receipt of your notice, okay? Then within 5 days after that notice of intent, so 35 days before the annual meeting, you can submit a candidate information sheet. It can only be on one side of an 8.5 by 11 piece of paper. And again, this is all statutory. These are not rules and regulations. This is all governed by statute. So your notice of your candidate information sheet has to be a one-sided 8.5, 11 page. It can say whatever it wants. Presumably, you're going to talk about your qualifications to run for your board, but we've seen others that say quite a bit more. And the association, we get this question a lot. Well, we've got this candidate information sheet and doesn't say anything about the candidate's qualifications, but rather is discussing about all the failings of the current board. And are we required to send that out? And the answer is yes. The Department of Business and Professional Regulation mandates that any candidate information sheet that is received timely has to be sent out with your second notice of annual meeting. That's going to include the ballot, and the association is not liable for any of the content of any candidate's information sheet. So it needs to go. If you do not include any timely candidate information sheets with that second notice, you're going to have a defective, what we call fatally flawed second notice, and we're going to have to renotice the annual meeting and resend out a second notice. Otherwise, your election is going to be subject to challenge and having to redo the election process. So,
Steve, can board members endorse other candidates including inside their own candidate form?
No. Well, a candidate can endorse another candidate. The association can't endorse a candidate. So if I'm running for the board and I also support another candidate, that's fine. But what cannot happen is the association cannot send out a letter on association letterhead and say that we support X, candidates for the board. Or say, for example, the current members of the board are running and, we request that you vote for us. So we can't use the association's name or its resources to endorse any candidate running for the board. But if I happen to be a current board member running for reelection and I want to endorse another candidate, I certainly can do that. Okay, so hopefully that, you know, there's a line there that we can't cross. Okay. So as I said, the second notice, any communication by the board, so formally by the association, can't endorse any candidates, but I think any candidate can endorse another candidate. Okay. Let me move this out of the way here. So, and I talked about this in HOA land. If we have less candidates or the equal amount of candidates running for however many positions there are open for the open on the board for that election cycle, then there's not going to be the need to conduct an election because we don't have a contested election. So if I've got a staggered board and there's 3 seats up this year and I've got only 2 or 3 candidates running, then they're going to automatically be on the board. And then if there's any other business to conduct at the annual meeting, that will be what we do. Now, if you're an existing board member, don't assume that by not putting in your notice of intent to run, that if there's not sufficient board members or sufficient candidates, that you're automatically going to be on. It doesn't work that way. So if you want to be considered, you need to put that notice of intent to run in. I had this happen to somebody, and it came as a shock that he wasn't going to be on the board for the following term. Okay. The other thing is here, which I didn't mention, there's the threshold for being able to conduct an election in condo land is 20% participation of your membership. So as I mentioned, in homeowners association land, you need 30% of your membership to be in attendance in person or by proxy. Whereas for condominiums, as long as we get back ballots that represent 20% of the membership, then we're going to have a valid election. Okay. We don't need to achieve a quorum in order to conduct an election. Okay. And most of the time I see the quorum requirement in condo documents to be a majority. So now that we've got the notice of intent form back and we've gotten our candidate information sheet back, it's time to send out the second notice of annual meeting package to the membership. That's going to include the ballot with all the candidates. We're going to list candidates on the ballot in alphabetical order by surname. And whether you're an HOA or a condo, that's the way you should do it. In condo, it's mandated that way. And the second notice can go out as early as 34 days prior to the annual meeting, but it cannot go out any less than 14 days prior to the annual meeting. So again, we're going to have the second notice, which is going to reiterate date, time, and place of the meeting, how many seats are up for election. We're going to have an agenda in the second notice for the annual meeting, which may be dictated by your bylaws in terms of what that agenda is supposed to look like. If you do have a specified agenda for the annual meeting in your bylaws, that's exactly what should be in that second notice. We're going to have the candidate information sheets. We're going to have the ballot, and then we're going to have the ballot envelope and the larger outer return envelope with instructions on how to complete the ballot and the envelopes and how to return them to the association. The other wrinkle that you run into in elections is when units are owned in a trust or an LLC, or you've got multiple owners of a unit. Then we get into issues like whether or not you have to have a voting certificate designating who's the authorized voter for a particular property, whether it's a homeowners association parcel or a condominium unit. That gets very complicated. You need to talk to your association counsel about how to manage that, as well as what instructions and any additional documents such as a voting certificate form being included with the second notice package. So again, if the process is not followed properly and we aren't dotting the i's and crossing the t's, we're subject to an election challenge, potentially by a losing candidate. Okay.
Steve, we have a couple of questions real quick. So
Sure.
the first one is, once they've sent out that first notice, if they don't get back a sufficient number of people who are running that warrants an election and no election is needed, do they still need to send the candidate information sheets out with the second notice?
No, I think in the second notice, you would simply, I mean, you can, the second notice would indicate that those individuals will be seated on the board at the annual meeting.
Okay.
So,
And
yeah, the candidate information sheet obviously is intended to provide the membership with information so that they can make an educated decision on who they want to vote for when you're having a contested election. But if we're not having a contested election and those people are going to be seated automatically, I don't know that it's not going to be fatal that you don't include those. But it might be nice for people to know who their new board members are. So.
And then can the association send out the notice completely electronically, especially to anybody who's opted in for electronic voting?
So if you can send the note, the second, you can send the first and the second notice electronically to those who have opted in for electronic voting. If somebody has not opted in for electronic voting, they're going to need their paper ballot and return envelope. So you're going to have to mail those folks, their ballot.
Okay. And can all board members have access to the unit owners' email addresses?
All board members have access to. Well, the only email addresses that are accessible to the members are those who have signed up for electronic notice. So if I have a candidate for the board who is an existing board member who has access to information that they would not otherwise have access to as a member, so that they can use that information to do an e-blast to the community, to basically, run their, a political campaign. I would say that that's a no-no. I would say that's no.
Okay, thank you.
Okay. So, the process for completing the inner and outer envelopes for a condo election is the same as I discussed before when you have an HOA that authorizes secret ballot absentee voting. Okay, so that's where that whole concept of secret absentee ballot voting comes from. In HOA land, it's been borrowed from the Florida Condominium Act. Okay, so again, that outer envelope is going to have to be properly completed. It's very important that the outer envelope have a space for a signature for the voter. If we don't have a line for a signature, then we've got a defective outer envelope, and we probably have to redo the second notice and resend out the whole package, and potentially delay the annual meeting. Okay, the way the division looks at defects in the notice process is, where did the defect occur? And that's the point in time where we got to go back. So if I have a defect in the second notice, I don't go back to the first notice and solicit new candidates or give people the opportunity to put in their notice of intent to run again. It's where did I go wrong in the process that I got to start over. Okay. And once you discover that error, you want to fix it as quickly as possible. All right. So again, the second notice is going to have instructions about completing the outer and inner envelope, returning the ballot. When you've got, let's say, 12 candidates running for 5 seats, your ballot is going to say, vote up to as many as 5 candidates. Don't vote for more than 5 candidates. If you vote for more than 5 candidates, your ballot's going to be disregarded. You can vote for less, but you can't vote for more. Okay. At which point, you need to then make sure you get your envelope back to the association by no later than the date that the annual meeting is going to be conducted. whether you hand deliver it, return it by mail or overnight mail, or have a member bring your envelope to the meeting. We did talk about disqualifications already a bit. Again, if that outer envelope is not signed, if you're not the authorized voter in a scenario where you have to have a voting certificate on file, then that's another basis for disqualification of the ballot. If we can't determine who you voted for because it's not clearly marked, or you've scratched out a couple times and it just isn't clear who you're voting for, that would be a grounds for disqualification. Or if we've got more than one ballot in the same inner envelope, then of course we're going to disqualify both those ballots. Now, one issue that comes up when we have electronic voting involved is, what if somebody votes electronically and then also submits a paper ballot? Typically, the way we handle that is we're going to count the electronic vote and we're going to disqualify the paper ballot.
Steve, before you move forward, so a couple of questions I'm going to get to now. The first off is voting certificates. So this was specifically for condo. Are they required for all condominiums?
So voting certificates is not a condo or a homeowners association question. It's really a question under your bylaws, whether your bylaws require it. So, when we draft updated, amended bylaws, we try to dispense with the voting certificate requirement by saying any owner of the unit is qualified to vote on behalf of that unit. And if more than one vote is submitted for the unit or lot, then the vote's going to be disqualified. Under older bylaws that were drafted by developers, there tends to be a paragraph that says, if the unit is owned by more than one person, then you need to file a voting certificate with the secretary. Some of them exempt, married couples. Some of them don't. When married couples are not exempt, that pisses a lot of people off who are married, saying, why do I have to, have a voting certificate? And then the other issue becomes with voting certificates from the division standpoint in an election challenge is, have you been enforcing the voting certificate requirement in your community in at least the last two election cycles? Because if an election challenge is brought and one of the grounds for the person not winning was because votes were disqualified because there were not voting certificates on file, the division is going to want to see 2 years of election records showing that you disqualified votes based on voting certificates. And oftentimes associations don't retain their election records going back more than a year because that's all the statute requires. So again, when you're getting into disqualifying votes based on voting certificates, you should really rely on legal counsel advice. And, I encourage you to have somebody at the meeting, when you're having a contested election, especially if it's a heated one, to oversee the election process, because these issues can get very complicated.
Yes, and that brings me to the next question, which is, if the unit is held in a trust, is that considered a corporation for purposes of a voting certificate?
Well, a trust is, it'll depend on how the documents are worded, but a trust is considered it doesn't fall into the category of a business entity. So again, it's questionable whether that would be required unless it specifically says trust. I mean, oftentimes when I look, what we do in situations like this, when Katie and I are overseeing an election, we'll look at the property appraiser website and see if the individuals are listed as well as in their capacity as trustee. And if they're listed individually and as trustee, we're not so much concerned about the voting certificate. You want to err on the side of counting the vote as opposed to erring, on the side of disqualification, because there's a presumption that you don't want to disenfranchise a voter.
Yeah, and let me just jump in. I am an election monitor for the state. So for trusts, the state takes the position that if it's the John Smith Trust and John Smith is the only trustee listed and John Smith is the one who signed the envelope, we're not going to disqualify that. But if it's the Sunshine Trust and there's nothing actually specifically stating John Smith is the owner or the dedicated signer, that's when that would come into play.
Right.
And then before you jump to the next section, Steve, could you please address the quorum requirements for the election or the actual annual meeting for condo, co-op, and HOA?
Yeah, so for a homeowners association, in order to conduct an election, the statute says, regardless of what your bylaws say, you need 30% of your membership to participate in person or by proxy to hold a members meeting, including to elect directors. So whereas with condos and co-ops, we only need 20% of the membership to participate in the voting process to hold an election. So while the primary purpose of an annual meeting is to elect directors, there may be other issues that are put to a vote by the members. You may be doing a document amendment, for example, at the same time. So if I'm a condominium association and at my annual meeting, I'm electing directors and I'm also asking the membership to vote on a change to the declaration of condominium, I may be able to hold the election because I have 20% participation, but I didn't achieve my quorum requirement necessary to conduct the vote on the amendment. So whereas with an HOA, that 30% applies to the election process and anything else I might do at the annual meeting, such as an amendment. So when we do a bylaw update for an HOA, we, of course, depending on what the board wants, we recommend, a lower threshold to hold the election. So at least that you're going to have sufficient participation for the election. I have communities that have dropped it to 25% participation as opposed to 20 because they feel that's a little too low, but less than 30. You cannot mandate anything higher than 30. So if your bylaws say for an HOA you have to have a majority in order to have a quorum, that's going to be trumped by statute, and it's still the 30%. So hopefully that
Thanks, Steve.
clarifies
And then
that.
for HOAs, if they're voting by proxy, but they're voting by limited proxy, are those records available so that everyone can see who the unit owner voted for?
Yeah. So yeah, when you're voting, if it's a limited proxy that if you're allowed to vote for directors by limited proxy and you got to sign the proxy, that's an official record and anybody can inspect those and see who voted for who, which is again why we recommend to encourage participation that, HOAs consider just implementing the condo style election process. So you've got that secret ballot and you have the ability to vote absentee, and you're most likely to get higher participation. Lisa will talk about the advantages of electronic voting, both as it pertains to secrecy and as it pertains to quorum. So there's some definite advantages there.
And then must the condo association mail out the second notice to foreign owners in more time than 14 days? It takes longer than that to get to Canada or Europe.
Right. So the statute says, that was recently amended, that the second notice can go out as early as the 34 days prior to the annual meeting. And the reason why they pick 34 days is because candidates have until 35 days to submit their candidate information sheet. So the day after candidate information sheets are due, assuming it's a business day, that second notice can go out to the membership. So it's really about, being ready to go, being prepared, and, depending on the size of your community, being able to get the package out. If you're a 50 unit condo versus 500 units, it's a different process, right? So it just depends on how big you are and how quick you can get it out the door.
And then one more really quickly, can you clarify the difference between the electronic distribution of the notice for people who have opted in for electronic voting, and then just also people who have opted in to receive electronic correspondence?
Okay, so yes, there's a difference between opting into electronic voting versus receiving notices of board meetings, committee meetings that need to be noticed, and members meetings, including the annual meeting electronically. So if I've opted into the electronic, we'll call it e-notification, okay? If I've opted into e-notification, that means I don't have to be mailed notices from the association through snail mail. I can receive it by email or, believe it or not, facsimile, okay? So if I provide a fax number, that's considered electronic notification, okay? So for board meetings, let's say the board is going to adopt a special assessment, and a special assessment notice normally requires 14 days mailed notice as well as posted on property. And I've signed up for e-notification. I don't need to get that by mail. I'm going to get it by e-notification. Okay. For a members meeting, other than for the election of directors, similarly, I'll get the e-notification. Now, if I haven't opted into e-voting, okay, then I need a paper ballot. So the association has to track separately for the election process who's voting electronically and who's not, irrespective of the e-notification. Now, the significant difference between opting into e-notification and electronic voting is the following. My email address is not subject to inspection or disclosure by the association to another member when I simply opt into e-voting. If I opt into e-notification, your electronic address, your email, is now the equivalent of your mailing address. And just like your mailing address is public record, okay, your email address now becomes available to any member of the association who wants it. Now, in my personal opinion, I think the legislature makes a mistake by doing that because it discourages e-notification, because people would love to get their stuff by email, but they don't necessarily want their email to become part of some owners list of email addresses and start receiving e-blasts from owners in the community, which we've seen time and time again. Of course, you can block that person as spam, but nevertheless, you're getting some emails from people you may not want to be. But that is the significant difference between e-notification and opting into electronic voting only. Anything else,
Thank
Katie?
you, Steve. Yeah, I'm just was trying to answer another question. One more question, and then I'll let you go forward. If there is no need in a condo or co-op for that notice, for the second notice to have an election, do they need to state the names of the candidates that are going to be filling the positions on the board?
I mean, I don't see why you wouldn't. I mean, I think you should.
I think you should, but I don't know that it's required, right?
It's not required, but you can say that we only received 2 candidates for 3 slots. We'll be announcing the candidates who will be seated on the board at the annual meeting, or you can just put the names in the notice. I mean, I usually, if I'm asked to do it, I put the names in, because not sure why it would be something we wouldn't disclose up front.
Yeah.
And then of course the other thing that's going to happen, which we haven't talked about, is you're going to hold your organizational meeting, following the annual meeting, to elect your officers of the new board following the election process. Typically that happens the same night. It doesn't have to. You can hold your organizational meeting up to 10 days following the annual meeting, but I wouldn't wait too long, because we want to know who's running the show, and you want to get your president, vice president, and secretary and treasurer elected. So, and it just so happens I'm on that screen, and that's the only time that directors get to vote by secret ballot, is when they're electing officers. Otherwise, anytime directors vote at a meeting, they have to do so, present and do a voice vote or a hand vote.
Okay,
And
thank you.
that is all I have, unless there's other questions.
No, so I think we're going to skip over our portion of electronic voting, and then Steve is
Right.
going to be here to assist Lisa with her presentation. So thank you all for attending our portion. So Lisa, you want to get teed up here to go ahead and put your slides up on the screen, and we're going to get started talking about electronic voting.
She gets to do the exciting stuff.
Hey guys.
Hey, thank you, Steve.
My pleasure.
Thank you so much, Steve and Katie. That was very informative. I learned a lot, I have to say, because we are the software providers. We don't know anything, or I mean, of course, we try to inform ourselves about all the rules and regulations. But Stephen, that was a very informative presentation. Thank you so much. And I'm gonna introduce myself again. I'm Lisa with IBA Technology Consultants. We're here to tell you about options of electronic voting. You heard a lot about the rules and regulations, what to consider, what is important when you have a board election, or maybe, just voting on an amendment. And we are going to show you how you can do that electronically, maybe avoiding fees for posting, etc., and just making the process a little bit easier and more modern. So what I'm going to do is I'm going to share my screen, and please let me know if you can see that. Give me 1 second. All right.
All good. Yep, looks
okay.
good.
Okay. All right. So yes, thank you for sticking around. I know it's a lot of information, and 2 hours is a long time, but as Katie already said, we are recording the presentation, so you can go back to it. We will also send you the slides to all those who are sticking around. Of course, you also get your credits, and if you have questions, as you did in the previous presentation, just post them in the chat, and my colleague Bobby will then alert me and let me know, when someone has a question that I can answer at a time that's relevant. So the slides. So welcome to electronic voting for HOAs and condos. What we're going to talk about in the next 45 minutes, because I also want to answer questions, of course, and we'll do that along the way, is why are digital solutions so important? What are the challenges? What are the benefits of electronic voting or voting in general, which Stephen covered a lot of those already. What are important features? And I think that's important for you to know. What can an electronic voting software provide you with that paper ballots cannot? We are going to go quickly over the requirements for co-ops, so condos and HOA, so 718, 719, 720. And we'll also provide you with an example of what a voting process would look like from a voter's perspective, but also what an admin, you as maybe a property manager, maybe a board president or board member, have to consider, and what's important for you and what you can achieve with using electronic voting software. And then, of course, any questions you have, please post them in the chat and I'll be happy to answer them. So just very quickly about us, our software is called Condu. We've been using or developing electronic voting software since 2015, when it became legal in Florida to use electronic voting for condos and HOAs for board elections. Also provide other software products such as property management software and web portals, which can be integrated. But if you have any questions about that, just let us know. So why are digital devices in general, not just electronic voting, so important? We believe that the communication between board members, property managers, and staff potential buyers, vendors, and of course, owners and tenants are just so much faster, quicker, faster and efficient if you use digital solutions. And that has become very apparent during the pandemic. You know, before everything was going via phone, via post, and then all of a sudden in 2019-20, we realized we cannot meet in person anymore. So what are we going to do? And associations, you know, they were forced to utilize digital solutions and realized, oh, it's actually not that bad. It saves us a lot of money. It saves time. It makes all the administrative processes a lot faster and easier. And that's also when associations realize that electronic voting can be a real benefit, both for the voters, but also for the people who have to deal with the ballots that come in, who have to count them and, you know, archive them. So, as I said, in 2015, condos, co-ops, and HOAs were allowed to, by law, to hold elections electronically. 2015, not that many HOAs and condos really looked into that, but you know, starting 2019, 2020, people realized it has a lot of benefits. What are those benefits? I mean, mail is very slow. We just heard in the previous presentation, you know, what about sending mail to Canada or to Europe or, you know, anywhere abroad? It takes much longer. It might not get to its destination in time, and people might not be able to vote. I always tell this story, so people who have listened to this presentation already know my parents own a condo in Florida, but they live in Germany, and they've never participated in an election because they never received the paper ballots in time, and they were never able to send it back in time for the paper to actually be submitted. So, I mean, that's a very obvious reason why, you know, paper votes have the disadvantages. In-person meetings for a time were not allowed. Thank God that's not the case anymore. We're all very happy about that. But nevertheless, you have to reach a quorum. And that's difficult because people might not actually be in town, you know, snowbirds, etc. You all know about that in Florida. So getting enough member participation might be difficult. What's good about electronic voting? Being in person at, submitting an e-vote counts towards a quorum. So you don't have to be actually in person at a meeting. Your e-vote counts towards a quorum. So it's much easier to reach a quorum if you use electronic voting. As I said, it's easy. It takes about a minute to actually submit your ballot. And the administrators, the managers, for them, it actually just takes a minute to read the votes, to have a result of the incoming votes. So rather than opening envelopes, looking at them, sending them out, it's a matter of a few clicks. And as we all know, time is money, so it saves the money a lot of, it saves the association a lot of money. Of course, you can store the ballots for as long as you like. There's no time restrictions when it comes to e-voting for how long your e-votes can be stored for audits, etc. And another topic that some of you might be familiar with is the privacy, the security, and also the elections might be prone to error. You know, you open an envelope, you have to type it in somewhere. Using an electronic system reduces or eliminates even the risk of false ballots, and the privacy and security is increased significantly. Of course, you always have to provide the option to people to submit a paper ballot. You can not just say, okay, our association is going to use electronic voting, and that's it. Everyone has to use it. No, of course, you have to give the alternative to use paper ballots. Nevertheless, a system should provide you with the opportunity to combine the paper ballots and the electronic votes and store it, report it, or in case of an audit, have all the results in one system, export it via PDF or whatever format you would like. So it's easy for you to follow, easy for you to archive and to present to whoever wants to see the results.
Hey, Lisa, we have one question, if you could.
Of course.
The question is, can the approval of owners for e-voting be used year after year, or does the approval need to be updated for each election?
Okay, that's a very good question. And once an owner has opted in to electronic voting, that is valid until this person decides to opt out or moves out of the association. So once you say, I want to use electronic voting, there's no need to repeat the process of activating the account. I'll go over that in a minute. You can just, you will receive all your opinion polls or ballots via email from then on. So it's just a one-time opt-in process. And of course, you should have the option to conduct secret and non-secret ballots, but I'll go into more detail for that in a minute. So what is important, what is useful, especially when it comes to voting software? So of course, it's important that you have to have a system in place where the owner's eligibility to cast votes will be secured. We already heard about, husband, wife, who is allowed to cast a ballot, and do we need voting certificates, etc., etc. So with the electronic voting system, I'm going to say 99% of the condos and HOAs will have one vote per unit or per home. So when it comes to electronic voting, what the association has to do, and this is a question that we get quite frequently, is to send opt-in forms, depending on whether you're a condo and HOA. This can be done via email or via mail, to the unit owners. And the unit owners will have to tell you, okay, this is the email address that will use electronic voting. It doesn't matter to the association or to the software provider who that person is, but only this person will be able to activate their account and to cast the ballot, because you want to avoid that people log in or change email addresses, etc. Of course, if someone changes their email address, they can do so, but there's a process involved. So the owner verification is very, very important. If you have more questions about that, we have a lot of information on that, but I just wanted to let you know that this is something that the association and the software provider has to take very seriously.
Hey, Lisa, one question for you relative to security from Joe Ellis. How do you counter the conspiracy theorists that reject any form of electronic voting as insecure?
Well, and I'm gonna talk about security. We have a very secure system based on blockchain technology. Of course, there's always people that are suspicious of any sort of online platforms. We can't provide you with all the security measures and everything that is related to cybersecurity for our company, but of course we cannot speak about electronic voting in general, because there are a lot of providers out there. So I think if you're concerned about that, you'll need to look specifically into the security measures that your electronic voting provider offers. And I can only speak to our company. We'll be happy to send you more information about that.
Which we do have a security statement as well, Joe.
Yeah. So going back to the features, secret and non-secret ballots, of course, are very useful. Sometimes you might just want an opinion poll. Just yesterday, we were talking about, or with an association, they wanted to have an opinion about lights at the basketball court. Do you think we need those? Yes, no. You can do that very quickly with an e-voting software where you don't have to go through the process of having an anonymous vote. So that's always useful. Proxies, we talked about, or not we, but Stephen talked about that in the previous presentation. And of course, the software should provide you the option to elect a proxy if you know, the association allows, and if you'd like to do so as an owner and as a voter. If the association allows nominations from the floor, then the software should be able to record those, to enter those as well. And if you have an association that allows fractional votes, let's say a 1-bedroom apartment or condo counts as 1.2, a 2-bedroom apartment as 2 votes, then of course the system should be able to combine those, to calculate those. However, it's a rare case. State of Florida nevertheless requires the system to be able to do so. If you have multiple properties, if you as a voter own multiple properties in a condo association or an HOA, of course, it's useful if the system allows you to combine all of those in one account, cast your ballots with one account. Nevertheless, it's also required by Florida statute that you can vote for different candidates, let's say, in a board election for your different properties. Probably it's a very rare case. Nevertheless, the software has to provide this option, just so you're aware of that, because you want to be compliant. Let's say I own 2 units. Unit 1, I want to vote for Joe. Unit 2, I want to vote for Jane. The system has to allow me to do so.
Hey, Lisa, we do have a question here.
Yes.
The question is, how much time does it typically take to get the electronic voting set up? And do we offer live virtual meetings / Zoom webinars to provide the information to members and explain the process and answer questions?
Yes. So yes, I mean, our company does. Of course, we'll offer demos and also webinars for as well as videos, tutorials for owners, and of course for admins. When it comes to setting this up, and I can only speak for our company, what our company needs is a roster of the entire association, because, you know, people move in, move out. Once we would have that, and we get the opt-ins, it's a matter of, you know, 5 to 10 working days to set it up with your help. But there's, of course, information that any company that provides electronic voting needs from the association. So a roster with email addresses, the opt-in forms, you know, what is the information about the election that is taking place. Nevertheless, I would say, if you have an election coming up and you want to use e-voting, start at least 2 months in advance, because you have to get the opt-ins from your voters. And that might take a while. You have to send out the opt-in forms. They have to reply. They have to say, yes, I want to use electronic voting. So 2 months prior to an election is a good time to get started. I hope that answered the question. So of course, the system also has to provide an easy way for owners to opt in and opt out. As I just mentioned, you know, owners sell their property, new owners move in. The company that you work with should provide an easy process for new owners to opt in to electronic voting. And of course, they also need an option to opt out required by law. To be honest, so far, I've never come across a case where someone opted out of electronic voting, but nevertheless, you have to provide that option. And what we also, what Stephen talked about, the email notifications. So of course, it's a lot easier for you as property managers, as board members, to send out notifications electronically, and especially to send out reminders. So if you have implemented electronic voting and let's say there's an association with 100 units, 80 people have opted into electronic voting, and 3 days before the election, you realize only 50% of those have voted. The system should be able to filter out those who have not submitted their ballot and send them a reminder, but not to everyone, only to those who have not voted yet. And this has proven very useful just to keep bugging those people who haven't voted and filtering them out and saying, hey, you have, you know, 2 more days, please submit your vote. And so far, this has helped a lot of associations to reach their quorum, to increase participation in votes, and to just make people aware of the fact that there is an election. There might be, you know, maybe if it's just an opinion poll, something important that's going on in your association. Another feature of electronic voting could be that you need voter groups. So let's say you have a master association, and within that association, you have different buildings or you have sub-associations. Maybe only certain people, certain owners in a certain building need to vote on a topic. Of course, you want to only provide those people with a ballot, with an opinion poll. If the software can provide that for you, that's very helpful. You can just send those people, you know, a ballot, a notification. Please join us in deciding on whether we need to renew our pool furniture or amend our bylaws, whatever it might be. Other features might be that you need to track attendance at the meeting, to just, you know, check off certain people, generate, of course, lists of e-voters and paper voters. And this is something that has been very useful for property managers. So at the day when you send out your paper ballots, because almost never there's 100% e-voters, let's say 98, nevertheless, you have 2 people that you have to send your paper ballots to. So the system, the e-voting software, should generate a list of e-voters and paper voters with their address, send it to the manager and say, these are the people that you need to send the paper vote to, and they can no longer opt into electronic voting because there needs to be a deadline, or there should be a deadline. When you say, okay, this is the number of people I'm going to send paper votes to because they did not opt in. And of course, that makes it a lot easier for you to have an overview to say, okay, if I get something back from those people, I can enter it in the system. Nevertheless, and this is also important for you to remember, if you use electronic voting, the system should not allow you to enter paper voters or paper ballots to units that have already submitted an electronic vote. I'll go over that in a minute, but of course, you know, that is something that's shouldn't be allowable to have 2 votes for 1 unit, paper and e-vote, and the system should recognize this.
Hey, Lisa, we do have another question here. Is it permissible to receive the names of non-participants to give them a call and not just an e-notice. We have found that necessary to get sufficient votes. So that would be the question.
Yeah, okay. I'm just gonna go in the chat quickly. To miss what receive the names of non-participants.
Right.
And I'm not quite certain what non-participants in e-voting. I'm assuming this, and not just an electronic notice. Okay. So if you mean by non-participants, that it's non-participants in e-voting, of course you're free to give them a call and say, would you like to participate in electronic voting? And if you do so, here's the link. Please activate your account and participate. That's I would say is permissible. Nevertheless, you do need actually an opt-in form, especially if you're an HOA on paper that someone says, I want to use electronic voting. So it's a bit of a gray area, I would say.
Okay.
Getting sufficient votes, yes, but of course you can always call people and ask them to join e-voting. I would say.
I got a couple more questions, Lisa. This one maybe we can reach out to Steve. The question is, thought board members can only vote at open community meetings except emergencies.
I don't know of anything in there that's dirty. Where?
Okay.
I'm not gonna put it in the grease. I'm gonna put it on top of something.
Hello?
Steve, are you there?
Yeah, I'm here. Can you repeat the question again?
Yeah, Steve, it's the question is, thought board members can only vote at open community meetings except emergencies.
Correct. So yeah, directors have to vote at a duly noticed meeting. They can.
Okay,
Yeah, sure, no problem.
Thank you, Steve. And then one more question, Lisa. Do condo bylaws have to be amended to allow electronic voting? Lisa or Steve?
Yes, so I mean I'm not the legal expert, so Steve,
My answer is no. So in other words, the electronic voting statute provides for a procedure to implement electronic voting. Your bylaws do not have to be amended. I mean, unless you have a bylaw provision that expressly prohibits electronic voting, which would be unusual. If it's silent on whether you can vote electronically, then the statute sets forth a procedure for the board to implement electronic voting. And that would not require a bylaw amendment. And that's true for condo. The statute reads the same for condos, co-ops, and HOAs.
Similar to that question, just as a follow-up, does the board of directors have to pass a resolution or make a special vote for allowing the e-voting process?
So yes, they do. And they have to provide 14 days notice of the board meeting at which they're going to consider adopting a resolution authorizing electronic voting. And that notice also has to be posted conspicuously on the property. There you go. So yes, so I'll let Lisa address that.
No, I was just gonna think it. Yeah, I mean, this is also only the information that yes, I've had. So as you mentioned, yes, well, the board must determine whether or not it will need to amend the association's bylaws and must discuss and approve e-voting and notify the homeowners of the meeting at which this will be discussed 2 weeks in advance. So Yes, thank you, Stephen, for clarifying all that. And when it comes to the resolution, we do have a template, but I believe it's always best to speak to Rosenbaum or, you know, your attorneys to discuss any of those legal questions. So just going back to what to look out for when it actually comes to the software, we had some questions about security and privacy. What you should look out for is that each client, that means each association, should have their own isolated web application. And that means basically that you should have an individual software instance and database. This is very technical, so I don't want to go into too much detail, but what's always important to look out for, no matter what software provider you work with, is that you ask them about a security statement, and also if associations share the same database, or if they have individual databases. Because what that prevents is that if someone is very, you know, technology savvy, can maybe hack into the database of another association, just being a member or a voter in another one. I mean, it happens very rarely, but these are very small details that are happening in the back end that you as a voter or as an administrator don't even know about. So I would always recommend to really have someone look into the IT infrastructure of your software provider. The reason why I'm saying that also is what to look out for. There are providers that allow in a secret election, let's say you vote for board members, to submit your ballot, which is supposed to be anonymous. However, then there are software providers that allow you to change your vote afterwards. So what does that tell us? If you submit a ballot anonymously, the identity of the voter and your results, the candidates you have voted for, should be separated. So that leads us to the conclusion that you cannot change your ballot again, because those two, the identity and the ballots, are no longer connected in the database. So if a software provider allows you to change your vote, a secret vote, after you've submitted it, that means they do not comply with Florida statute, because as you know, same case, you submit a paper ballot, you send it out, you cannot go to the office and say, oh, you know what, that inner envelope, that's mine. They shouldn't, you know, be able to connect an identity or a unit to a ballot. And that's the same case with electronic voting. So please be careful, because there are cases in Florida where elections had to, you know, be redone. They weren't, well, the people said, you know what, I think this is not compliant with the statute, because I was able to change my vote. So please make sure that if whatever provider you choose, they do not allow that when it comes to secret ballots.
Hey, Lisa, we've got another question here, kind of a few of them at once. The question is, if electronic ballots are coming in over a period of time, are the results held until a specific time when the paper ballots are counted? I think in a board election, that would be the case. How does this all work with vote results? Would there be a delay in obtaining results? I'm trying to understand how it can work simultaneously between paper and electronic.
Okay. Yes.
Hopefully you got that.
Very good question. So what happens when you have a secret ballot? I mean, board elections are really what, you know, everyone is concerned about. And that's always has to be a secret election, anonymous election. When electronic voters submit their ballot, the administrator, of course, only the administrator or administrators, plural, can see which unit or which home has voted already. However, they cannot see the results. They cannot see candidate A has 30 votes, candidate B has 40 votes, because this can only be visible to anyone after the election period has closed. So let's say we have election night on December 1st. I have all my electronic votes in. I see 90 people have voted electronically, and I have my 40 paper ballots here in front of me. What will happen then is that as an admin, the election, the electronic voting election will be closed. I can see the results, you know, who has won, who is in second place, third place, etc. And then you can enter as admins, and we always recommend there's more than one person who, of course, enters the paper ballots. You can enter the paper ballots into the system to have a combined result. Now, this is not required by Florida law. You do not have to enter the paper ballots into the electronic voting system. You can have two separate results, one for e-votes and one for paper votes, and then just, you know, calculate those. Nevertheless, it makes sense to have that archived somewhere, recorded somewhere in the same database. Now, what you could do then as an association is to enter the paper ballots into the electronic voting software anonymously. And here it gets a little, well, not complicated, but there's two steps involved. You have the outer envelopes and you have the inner envelopes. You separate both, as you do anyways. You enter the unit numbers or home addresses of the people who have entered a paper ballot. And then afterwards, you shuffle the inner envelopes, you enter those results in the database, and you end up with a combined result. And ideally, you do that at election night, or you've done it previously with the paper ballots. That's not, you know, that's up to the association. And then you will have a combined result, and the system will tell you who voted on paper, who voted electronically, etc. So I'm not sure if that answers the question, but I hope so.
Hey, Lisa, we got a couple more, like, if we want to attend to them. This one here might also be you know, for Steve. If you hand in your paper ballot but want it back to change before the election, can you give it back to them if it has not been opened?
So typically, once the ballot has been submitted, it can't be rescinded. If we're talking about a secret ballot voting process.
Okay, election.
Yeah.
Okay. All right, that should answer that. And then can you, the second question here would be, can you share vote tally before the final results? And I think on a non-secret, you certainly could. Lisa?
On a non-secret, but that's, you know, it's not an official election. It's more like, you know, an opinion poll. So the software can do that, but it's not comparable to electronic voting for board of directors election. Right. So you cannot do that for a secret election. No, you cannot.
Okay, thank you.
Okay, so I'll just continue a little bit about security with the information. Make sure you have the provider has certified data centers. You know, there's certain standards that every vendor has to comply with. Just make sure you get a security statement. You have all of that information. Backups, same thing. It should be a given, but nevertheless, you know, make sure that you get some information about that. And of course, also in the fine print that no email addresses, any information about the owners will be sold to third parties. as we already mentioned, the secret ballots should be stored in a tamper-resistant ledger database, which should make it practically impossible to alter stored ballots or, to change any ballots once they are stored in the database. Again, this gets a little bit technical, so if you're into that information, we'd be happy to provide you with information about our ledger database, our blockchain technology, etc. But I'm not going to go into detail right now to that. So as we already mentioned, the procedure is relatively clear. You might have to obtain a resolution, choose a vendor, notify the owners of the board meeting at which this new e-voting system will be discussed. And then, of course, there comes the whole enrollment process. Now, how does this work? I'm just gonna, because we already discussed this. So members must consent in writing to e-voting. And Stephen, let me know if this is not correct. From what we know, that 718 condo associations are allowed, once they have consent, to send e-notifications, emails to their owners, that they can send the opt-in forms via email to owners. HOAs, I believe, have to send the instructions to opt in and the consent forms via mail or post.
So, yeah, I agree with 718 that they have to, they can, if somebody's opted into e-notification, that they can get the consent form electronically. I mean, I think practically speaking, many homeowners associations are going to have a website, and somebody could download the consent form from the website and, return it to the association. And I think they can return it by email. As long as they're, as long as we can tie the consent form back to the property owner, I think it would be valid.
Okay, thank you.
Hey, Steve, as long as you're here, I have
Yeah.
one for you. This one is, how about votes for amendment changes? In the case where the owners vote against the change and therefore be grandfathered into a pre-amendment change, the association would need to know how the vote was cast for that amendment in order to allow these owners to stick with the grandfathered covenant.
Yeah, so like if we're talking about some type of lease restriction amendment where people voted no, but the amendment still passed, my understanding from everything I heard from Lisa is, we're able to identify on an amendment vote who voted yes, who voted no, and the association is going to be able to keep track of that until the properties that voted no change over, because once the property is sold, a new buyer would be subject to the restriction. So I think that's easily tracked, through the system, right?
Correct.
Lisa, might as well wrap up these questions here. Once a resolution for electronic voting has been passed, is it then established for all votes moving or going forward?
I believe so, yes. So the electronic voting is in place, but of course people can opt out and say, I want a paper ballot for any upcoming votes or elections. Nevertheless, the system has been established, so people who opted in can use the electronic voting for, however long the association decides to use it. I hope that is correct, Steve.
Yeah, no, I think at the end of the day, it's at the board's discretion if they want to conduct the electronic voting after they've implemented it. I can't imagine why they wouldn't. And, as you pointed out, as long as they've continued to engage the vendor, they've got the platform to use. The resolution would usually specify deadlines to opt in and opt out. So when there's some, if somebody doesn't want to vote electronically, they have to opt out by a certain time frame prior to the next meeting at which a vote is going to take place to the membership. So that's the only thing I would caution, is you need to be mindful of what your deadline is to opt out if that's the direction you want to go.
Thank you, Steve.
Sure.
Lisa, one more, and then, hey, how many slides are we looking at, Lisa, left? Time-wise.
I can just, wrap it up before 12, of course. No
Okay.
problem.
All right,
Go ahead.
The question is, which I think may have been answered, does the system allow voting on other issues other than board elections, like, polling, surveys?
Of course. So you can have as many elections, at least with our system, as you like per year. You can do opinion polls, secret elections, non-secret elections. Do we need new furniture in our lobby? I mean, whatever you'd like. The system should allow that, but of course I can only speak for our system, but it makes it a lot easier to just get a general opinion on certain topics and to vote on, amendments, etc.
Thank you.
All right. So I'll just go quickly through these. These are the requirements for online voting systems in the state of Florida. Of course, you have to authenticate the unit's owner's identity, authenticate the validity of each vote, which a system should do automatically. The system has to send a confirmation to every voter who has submitted a ballot saying we have received your ballot, and you voted for A, B, C, D, whatever that might be. Of course, this should go out automatically through the system, but it's only visible to the person who voted, only to the voters, not to administrators, because it's of course an anonymous election and the system has to provide that. So you have to make sure that whatever software you use will allow that. This is the receipt. You have to transmit a receipt. What's also important, and I'm not sure if I mentioned that previously, is that you have to make sure that the electronic device of a voter can communicate with the e-voting system. Sounds more difficult than it is. It's usually just a matter of setting up a demo vote. Something like, what's your favorite color? What's your favorite music genre? Something like that. And owners can then submit their vote and make sure that it's submitted correctly and that they receive a confirmation of that vote. So that's really all that's involved there.
All right, one more question for you, Lisa, if you could.
Of course.
For amendment changes, can they still be sent by electronic voting, or are they required to do a hard mailing since it is an amendment change?
No. It's an amendment change just as any other vote. If the board has voted to allow electronic voting, if they have decided to do so, it can be done electronically.
Thank you.
Any other vote, yes. Just another feature or another requirement, of course, the system has to store and keep electronic votes accessible to election officials for recount, inspection, review purposes, if so determined, indefinitely, really. So that should be given. Nevertheless, make sure that your system, your provider allows that. So just to sum up, as we realized in the last 2 hours, regulations for HOAs, condos, they always differ slightly, and make sure that you talk about implementing e-voting, or before you do so, with your attorney, and just discuss all the questions you have, the legal questions with them. ADA compliancy has been a very important topic, especially it was in like 3 years ago. ADA compliancy just means that whatever software you provide, whether it's just a website, whether it's e-voting, or an app, is, for example, accessible to people with visual impairments. So always ask your software provider, is our system ADA compliant? Because you don't want to get fines for, you know, not be able, or for your, let's say, visually impaired voters to be able to read the information that is on the portal properly. It's always good to have a demo, you know, make sure that it's user-friendly. We are in Florida, so, you know, you have to also give information or provide the information to people that don't use their smartphone or their laptop every day, that are used to paper votes, and maybe they want to switch, but it has to be an easy process. It has to be safe and secure, and people have to feel like, yes, this is better than paper votes. So demos are always good, and user friendliness should be a priority. And I'm just going to look at the clock. Do we have any more questions, Bobby, or should I just?
We're all set right now. If you want to just.
Okay. Yeah, so I'll just show you an example of a voting process from a voter's perspective, very quick, and then I know you all probably have a very busy day. So what would it look like if I sign on, I opt into electronic voting? Once the association has established the process and they decided, okay, we send out the opt-in forms, we received opt-in forms back, we send those to our software provider. The software provider will generally send out an invitation to join an online voting portal via email to the email address that has been mentioned in the opt-in form. So in this case, Harold can then activate their online voting account by clicking on a button in an email, and they will be redirected to the activation page. Of course, here only the email address that was mentioned in the opt-in form has the opportunity to, that person has the opportunity to activate their account. If I want to change the email address, the system won't allow me, because that, you know, would make it easy for people who are not actually residents or owners in an association to just click on a link, or, you know, you forward a link and then be in the online voting portal. Of course, that's a no-go. So the email address is set. I'll choose a password. I confirm the password and I activate the account. I'll then receive another email that the account has been successfully activated and I can now log into an online voting portal. So I'll click on that button and that's it. And the activation process, of course, doesn't have to be done every time that an election is taking place. This is a one-time process. After that, I'll just go to the link that I'm being sent when a new election is taking place, or an opinion poll, and, you know, I enter my email address and password, and that's it. So in this case here, the votings are a board election, board of directors election, and some opinion polls. Of course, I can opt out of electronic voting here, relatively easy. And I can also select or remove a proxy. Not going to go into detail because we're running out of time. So here I can select up to 3 members for my board of directors election. Of course, I can also look at the profiles of the candidates. Usually, you know, you have like a CV or just some background information. What's important is that the system can, of course, restrict entries. So in this case, I, as a voter, have to select at least 1 and at most 3 responses. You know, with paper ballots, you say only choose up to 3 candidates, and then people check or choose 4 candidates, and that renders the ballot invalid. Of course, you don't want that. You want to have as many valid ballots as you can. And in the case of electronic voting, the system wouldn't allow me to submit a ballot if I choose more than 3 responses in this case. And of course, that's customizable for every election. So here you can also see this person that's voting owns 5 properties. Of course, for each property, I can choose different candidates. I select a proxy.
Hi, how are you?
Hello. Okay, so if I want to submit my ballot, I have to confirm my identity, agree to submit the ballot, enter the password again, and that's pretty much it. I will receive a confirmation via email, which tells me who I voted for, but as I mentioned, this is something that only the voter will see. No one else will be able to actually connect the entries to an identity. Not going to go into proxies because we already talked about that in the previous election. So it's really, when it comes to electronic voting, as easy as for a voter logging into the software, choosing the ballot, selecting, your candidates or your answers, and submitting the ballot. And this takes, just a few minutes. And you're done. You're saving the postage, you're saving a lot of time, and of course the risk of the actual paper ballots not getting there in time. And when it comes to actually administrating votes for the property managers, so far I can only say it has saved a lot of time, although, and of course you have to keep this in mind if you want to implement electronic voting, the onboarding process takes a little bit of time. You have to get people, to understand what electronic voting is. You have to get them to opt in, but once that's done, then, it will, the whole voting process, setting out or sending out opinion polls, etc., will be a lot easier. Nevertheless, the first steps, there's a little bit of work involved, as with any new system that you introduce to an association. Are there any more questions?
I've got one question here for you, Lisa.
Yeah.
Does our system have the option for voters to view the information in multiple languages?
Okay, so I'm just gonna, so yes, if you want, let's say you want to have information in Spanish and in English and maybe other languages, it's possible to do so. Of course, you can upload the candidate information in multiple languages, and the results, I mean, for the admins, of course, now I'll just have to check on that. Let me check, but yes, that is possible. Sorry. Yes. So multiple languages, however, so far I think we'll stuck to Spanish, French, English,
And German.
yes. Okay, so I see there's also the a question about the costs.
I've got those answered, Lisa. All set on those.
Yes, if you have questions about costs, because this is strictly about electronic voting, not about our company, we'll be happy to send a proposal. However, we can't discuss this within this meeting.
I think we're set on questions. Katie?
Great. Thank you guys so much for attending. A couple of quick little housekeeping things. You did just receive a poll. We appreciate your feedback. Both Rosenbaum and IBA Technologies are offering the 1 CE credit for managers. Please allow 5 to 7 business days before you see that credit. DBPR has been somewhat slow in getting those things loaded, especially if we're loading from a bulk upload. I know for Rosenbaum, we use a third party to issue our certificates. Those do come electronically. Please check your spam folder. If you do not see that by Monday, then reach out to me, but check that spam or junk folder and see if it's there first. And I know that Lisa and Bob, they will be issuing the certificates for IBA Technologies. And we will also have a copy of the recording. Just my last disclaimer again, that we do not offer CE credits for anyone who is not in attendance today at the actual live Zoom webinar. So we are happy if you want to share with people the information on the recording, but you will not receive credit unless you were in attendance today, and we have a record log of that. And with that, thank you so much. We will also be sending you a copy of all of the business partners' contact information, the slides for both classes, and the recording. And we really appreciate you guys attending and hope to see you at our future events.
Thanks, everybody. Thank you, Steve, Katie.
Thank you. Have a great day.
Thanks. Bye-bye.